Hello, my name is Frans Rautenbach. I'm a lawyer at the Cape Town Bar, and I've been thinking about an argument to attack the Labour Relations Act on constitutional grounds. One of the difficulties with doing that is that, for obvious reasons, if you suggest that the entire Labour Relations Act, which is after all designed to protect the rights of employees, is to be scrapped, that would have very severe consequences. A somewhat less invasive way of doing this is to attack Section 5 of the Labour Relations Act. Now, Section 5 is the section which says that no employee may waive the benefits of the Labour Relations Act. In other words, any right that exists under the Labour Relations Act may not be contracted out of by the employer and the employee. Now, the basis on which I think this should be done is threefold. The three relevant provisions in the Constitution are Section 9, the equality provision, and as you will see, that's the most important one, but then also the universal right to fair labour practices in Section 23, and the right to protection of human dignity in Section 10. So I will briefly refer to fair labour practices and human dignity, but most of my time I will spend on the crux of the argument, which is the equality provision in Section 9. Now, Section 9 basically guarantees that everybody is equal before the law and has the right to equal protection and benefit of the law. And then this particular provision is also important, which says that equality includes the full and equal enjoyment of rights and freedoms. It is on the back of that I want to then build the argument by reference to the common law right of freedom of contract. Surprisingly enough, our law does not have in the Constitution any provision protecting freedom of contract, which is a sad omission, but one which we can rectify by reliance on the right of equality in the Constitution. And the argument works like this. The starting point is to say that we must recognize that the right to freedom of contract is very much part of our law. But part of the common law, that means the law as developed by the courts. And the common law is preserved by the Constitution, except insofar as the Constitution expressly overrules it. Now, the Supreme Court of Appeal has held, for example, in the matter of Brisley versus Drotsky, that the Constitution's values of dignity and equality and freedom require that the courts approach their task of striking down contracts or declining to enforce them with perceptive restraint. Let me interrupt that quotation simply by saying that the contract, obviously, that we're talking about here is the employment contract. And the right to contract out of the provisions of the Labour Relations Act. The quotation then continues, one of the reasons, as Davis J. has pointed out, is that contractual autonomy is part of freedom. Shorn of its obscene excesses, contractual autonomy informs also the constitutional value of dignity. In other words, what the court recognizes, and this is really important, is that the dignity of a human being is very much dependent on his or her ability to make their way in life by earning their own income through employment, or otherwise by contracting to secure their own commercial rights. And if you take that away, you take away a person's dignity. Now, by the same token as the court has said that it should not strike down contracts all too readily, By the same token, the legislature should be slow to prohibit contractual terms that consenting parties freely agree to, subject to the constraints of public policy contained in the Constitution itself. In other words, if the courts are the law is trying to strike down contracts or prohibit contracts, we must take the legislature to task, and that is exactly what I intend doing. So the attack is firstly based then on the equality provision, which says that equal treatment is due to everyone, and everyone is entitled to equal benefits and enjoyment of freedom of contract, being one of the basic rights under the common law. Of course, equal freedom of contract does not mean that everybody is entitled to the same rights or benefits. Much less does it mean that every employee is entitled to a job. But what it does mean is that every employee should at the very least be entitled to negotiate for a contract and conclude a contract. If the law prohibits a contract by saying that there shall be, for example, a minimum wage below which an employee may not be contracted, the effect of that is effectively to deny that employee freedom of contract. Such an employee can then not enjoy freedom of contract in respect of his own employment contract. That means that a worker like that is in effect disempowered, and I will, in the rest of this argument, refer to such workers as the disempowered group. In significant contrast to this, we find the so-called empowered group, and those are the workers who, by reason of training, experience, schooling, or otherwise, are able to command the terms and conditions imposed by the Labour Relations Act. So, for example, if there are minimum wages imposed through bargaining councils, or other terms such as the right to approach the CCMA, or the right to strike, or the right to join a trade union, all of which impose costs on employers. Some workers have strong enough bargaining power that they can say, well, I want a job, and I want a job under all of those terms, and the employer is obliged to grant them those jobs. And the thing is, an employee with that kind of bargaining power effectively has strong bargaining power, sufficient bargaining power, so as to exercise his freedom of contract, by contrast to the disempowered group. All right, now Section 9, and we don't have to worry about this, has been applied by our courts to direct discrimination, but also indirect discrimination. So insofar as it may be contended that the discrimination that is affected by Section 5, which says that no employee may contract out of the Act, and which thereby discriminates against employees of the disempowered group. And so far as someone may say that this is an indirect form of discrimination, that is no problem. The law applies to direct as well as indirect discrimination. So what it makes clear is that employees who fall under the threshold imposed by law, that is by the Labour Relations Act, and who are too weak in their bargaining power by reason of their socio-economic circumstances, are therefore the subjects of discrimination by the law. The law effectively discriminates against them on the basis of their socio-economic circumstances. They are too weak in bargaining power by reason of their lack of training, lack of education, lack of English or Afrikaans, or whatever it may be that holds them back, that enables them not to be, does not enable them to command the terms and conditions of the Labour Relations Act. Whatever that is, those grounds are then effectively used by the legislature to deny them the right of freedom of contract. Now, by the same token, Section 5 is also in breach of the right to fair labour practices, as it unfairly compels both the employer and the disempowered worker to contract on terms prescribed by labor law or not at all. And we all know what that means. That means not at all. This is self-evidently unfair as it deprives workers in the disempowered group of jobs and income. And the third ground which I mentioned is the right to dignity, which is ensured by Section 10 of the Constitution, and which says that everyone is entitled to the right to human dignity. Now, as I've already said, the right to work and earn a living and earn your own income and make your way in the economic world is part of human dignity. To say to someone that you may not effectively contract for a job is to make a severe inroad into that person's right to dignity. Now, of course, the counter-argument will be that there is a Section 36 in the Constitution which says that each and every right in the Constitution, in the Bill of Rights in the Constitution, may be limited by a law of general application. And it says that the rights in the Bill of Rights may be limited only in terms of law of general application, to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors. Now, I'm not going to go through all of these factors, but let me just say that the basis for this limitation, for the permissible limitation of any such a right, that is, to the right to equality, to the right to freedom, to the right to fair labor practices, and to the right to dignity. Any such a limitation must be justifiable in an open and democratic society based on human dignity, equality, and freedom. Now, one of the arguments which goes with this objection is that our opponents will say, but if you allow the parties to contract out of the Labour Relations Act, you effectively render the Labour Relations Act nugatory, because then everybody will get their employees to contract out of the Labour Relations Act and nobody will in fact be subject to its terms. Now, that's obviously not correct, because as matters stand, we know that there are employees who can in fact contract within the terms of the Labour Relations Act, otherwise they would not be employed. But quite apart from that, let's just for a second consider the implications of an argument like that. I've already pointed out that it is the empowered group which is able to exercise their right to freedom of contract, and the disempowered group which is not entitled to exercise its rights of freedom of contract, which means in effect that the law contracts them, or the law prohibits them getting a job. Now, the difficulty is that any argument which says that employees who are currently benefiting from the Labour Relations Act will be exploited in that they will lose the right of the Labour Relations Act, because they will be exploited in the form of the employers insisting that they contract out of the Act. If the employers say they must contract out of the Act, that would in their case be unfair to them. But the fact of the matter is, those are the employees of the empowered group. They are still, as we stand, strong enough to contract for jobs while the Labour Relations Act is still in existence. So they are the stronger group. They are the empowered group. And any argument which says that the employees of the disempowered group should yield, should, in other words, come second in line, and that the empowered group must get preference above them, is surely not a fair argument. The point is this: no open and democratic society based on freedom, equality, and dignity can possibly countenance a state of affairs where the stronger, the right of the stronger, trumps the right of the weaker. In the matter of Hoffman and South African Airways in 2001, the Constitutional Court held that our Constitution protects the weak, the marginalized, the socially outcast, and the victims of prejudice and stereotyping. It is only when these groups are protected that we can be secure that our own rights are protected. That is the fundamental reason why the prohibition of waiver in Section 5 is not a justified limitation of the applicable constitutional rights. It also demonstrates why the right to fair labour practices of the empowered group can never trump the right to equality, fair labour practices, or dignity of the disempowered group. Protecting the empowered at the expense of the disempowered is so self-evidently wrong in the context of our constitutional jurisprudence and policy that it behoves no further argument. I have no doubt that this argument will succeed.